आपने चलिए My lord, may I be permitted to mention one matter? Regarding 32,000 primary job, the matter has been assigned before your lordship. On Thursday, matter was mentioned by some of the party. Your lordship was pleased to direct the parties to serve notice and mention. All the parties are appearing before your lordship. My lord,
We
I
have also served
I am
notice,
proposing,
my
my lord,
mention.
let the matter appear under heading to be mentioned, and on that date, let a date be fixed for consecutive hearing.
Why any other parties have been left out?
No, my lord. Still,
My lord,
there are Lordship may
there are other
hearing, my
councils,
lord.
Madam, may I say, Madam, I
There
am
several
representing the candidates who are serving for 4 to 5 years.
We are representing everybody.
Yes, lordships are representing for both sides. So lordship has no choice. Like we have a choice. We can afford to shut our eyes for some other aspects. Now, my lord, what I feel, there are large number of matters. So lordship may keep it under the heading to be mentioned for one day, so that, my lord,
How many matters are there?
more than 30 minutes.
my lord, mainly
the involvement is 36,000.
32,000.
The learned single judge,
32,000.
my lord, effectively set aside our service, went before the honorable division bench, then Supreme Court set aside the order of the learned single bench and ultimately directed the honorable division bench to hear out the matter. So one day maybe for may I say, ultimately it is a question whether we would.
The thought we
Yes.
were inquiring from the junior counsel who was
Yes.
mentioning
Yes.
that whether all the advocates appearing for all the parties in all the writ petitions can be served so that we can fix a date for hearing.
My lord,
Exactly, that's
All
what I'm
the
saying.
parties are there.
I'm saying that.
have been served.
All the parties are there.
So then we can fix a date for
Yes,
hearing.
Better.
Well,
Lordship
what
may
I'm
state
saying is, kindly keep it under the heading to be mentioned on that day in presence of everyone. Lordship will fix a date. That would
All
be.
are here.
Yes.
It cannot be assured whether all are here because number of appeals and number of petitions are there. So, my lord,
But I have.
Those have not been assigned to us.
My lord,
No,
subject
the
to the
appeals-
Bunch
But
has been
let I
the entire branch has been assigned.
Right. Well, I stand amended. Lordship may fix it. I have no difficulty.
My lord, subject to correction, my lord, MAT 873 is the main appeal, my lord. The filed by the board.
Hmm.
Let the board begin. If they have anything to
Board is
supplement,
not here.
Board is not here. Board is
what's not is served, my lord. Not is served.
My lord,
We
may
should
I
serve
please-
again.
my lord, may I
Right,
play
we are
one thing,
keeping
my
it
lord?
as to be mentioned, but on that day, if possible, we can start the
Yes,
hearing
yes.
and fix another date for him.
At
But
least
on
Lordship gets a bird's eye view of the matter, my lord, because
The third,
But we shall appeal
My lord, one thing, may I
just a moment.
submission. We are for the applicant, those who are not in service. And we are appealing to your lordship, my lord, a date.
Consecutive dates.
Consecutive.
Consecutive dates.
Suffer.
But first let us start.
well, there are.
Also,
my lord, one thing, may I pray, my lord, my counsel will be out of station, my lord, for this week, my lord. May it be on the next
Let
week,
the
any
board
day.
submit, my lord. No,
Any day, next
cabinet
week,
has to be mentioned.
to be mentioned any day next
Your
week.
lordship,
my lord.
So
Lordship is,
why next week? It will appear this
well,
week.
Lordship is keeping it on
23rd.
23rd.
but 20. This matter, my lord, this matter, there is a usually there is a request that because when it involves after the SSC
So
judgment.
we will hear you. We will hear
No,
you.
I'm not hearing. Well, only I'm saying Lordship is fixing on 23rd. 23rd, another big chunk matters hearing has been fixed starting from 10:30. Only one request any day other than 23rd. But 24th, 24th.
24th কি পার্থর সাথে না যে ইয়ে মান্থার সাথে will be 24th to be mentioned.
Obliged.
Grateful, Your Lordship.
Have you given the numbers of all the matters?
Madam, while it was,
That is the assignment. notice, sir.
yes.
That is the assignment notice.
ওটার first হবে নিতে হবে। You are not
Council will not be.
You are a council
To start,
also.
to start on.
You are appearing for whom?
I am for the appellants, my lord, who are in service in this.
That I'm,
Tactics, man. This is nothing but
Nothing
delay
delay
tactics. man.
You are in service.
Yes,
So what do you want?
but I am only paying, may it be on 25th instead of 24th, as to be mentioned, my lord.
চলো 25th.
Let the matter be appeared tomorrow, my lord, in that case.
Yes,
Matter be on tomorrow, my lord.
28th has to be mentioned.
Deeply obliged.
And be ready with the matter.
Yes, my lord.
You start your argument, ask whoever is your counsel.
The board will start in that case.
In any case,
Who is
my
for
lord,
the-
notes
you're
of
for the board?
arguments have been
No, no,
already
no. I'm for the writ petitioner.
Who is for the board?
Mr.
Board-
Subish Shankar.
Mr. Loki Gupta is the London Senior Counsel is appearing.
Give a notice to them that it has been kept
We
on.
have already, we shall also.
We shall.
Yes, next.
notes of argument has already been, my lord, filed in the previous.
My lord, may I have your lordship's kind leave, my lord, to mention the matter in which lordship was pleased to direct paper books, my lord. Paper book have been deposited with the department, my lord, and a copy has been served with the learned counsel for the appellant in one matter and respondent in another. It's a joint appeal by two parties, my lord, to the writ petition, my lord. Praying for inclusion.
Combined listed the other.
Lordship, may I
Yes.
comment for
For what application or hearing? Uh-huh. Habeas a fresh file.
2024.
24. Where is your notice to the other side? Have you given notice and mention?
4 weeks of
Give a notice and come back and mention. Yes.
matter related habeas corpus.
Please don't mention without notice. You are mentioning with notice.
Notice.
That
Already
you will be
notice.
mentioning today.
Today, before 7 days ago.
So you have to give a notice. What is the matter?
Related habeas corpus.
Habeas corpus. To give a notice to your other side and tell us on Thursday.
Okay, thank
Yes.
you. Habeas corpus, it's fresh matter 2025.
Fresh matter.
But mention for inclusion, habeas corpus is a fresh matter.
Pardon?
Habeas corpus is a fresh matter of 20.
Fresh matter. Yes.
With the kind
Lordship,
leave of Honorable Justice Ritabroto Mitra, my lord.
Wait. Yes.
Lordship may be permitted to mention appeal under section 19(1)(a) of the Contempts of Court Act. Lordship may.
Yes. You are giving notice. You have
Lordship
given
is a fresh matter, Lordship. New matter. I mean to say, this for the first time hearing, Lordship.
All right. The application put a record hearing it. Yes.
With the kind leave of Honorable Justice Ritabroto
Any
Mitra.
other mentioning in the regular bench? In the regular bench, any other?
Yes, ma'am.
Say yes.
His Lordship, may I Lordship have your Lordship kindly to Lordship, Lordship, upon notice to the other side. Lordship, may I have your Lordship leave to mention for extension of interim order. Lordship, the interim order is still end of April 2025.
Who
Lordship,
has passed the? We passed the.
yes, Lordship. Yes, Lordship. His Lordship passed it
Till
on.
the end of April.
Yes, Lordship. Lordship,
You are
may
mentioning upon notice.
yes, Lordship. Yes, Lordship. I am mentioning upon notice. This is the
Watch on the list. Is
Lordship.
any other mentioning before
Yes,
this
my
bench?
lordship. My lordship, I came on last Thursday and regarding the habeas corpus, you told me to serve the notice to the opposite party. Me and my senior, Mr. Udashankar Chattopadhyay, has requested other side to take the notice, but he refuses on Thursday and Monday. His name is,
It's a fresh matter.
no, it has been heard one time.
It has been hard. It is
Ah.
in motion stage. Near now, yes.
Much obliged.
My lord, on original side matter, my lord.
Original side.
My lord, it is an assigned matter in September 2024. Thereafter, my lord, I have.
Sir, what can we do? See, bench, we hard matters sitting with Justice Chatterjee, benches. Everybody insisted keep it part hard.
No, my lord.
We have partly hard, we have
it is a
kept it.
assigned
Now
matter.
see our position.
Assigned matter not come for a single day, my lord.
Give the slip, let us see how can we
My lord,
place it.
As
We
it,
cannot-
at least as a to be mentioned on the next coming.
Don't worry, sir. You give the slip letter. একদিন না
Don't worry.
সাহেবের সাথে বসে নি অরিজিনাল সাইডে কোনগুলো অ্যাসাইন্ড আছে
Matter, my lord, but passed by your lordships and my lord, Justice His Lordship, my lord, Rajabasu Chaudhary, my lord. Habeas corpus matter that time, my lord, visitation is not given to the father, my lord.
রাজার সাথে একটু কথা বলো কবে কি remind us next week also. Let us.
Next, my lord.
Yes,
My lord, with the kind leave of Honorable Justice Ritabroto Mitra, my lord, this is a matter
that
of
OBC.
OBC,
Yes,
my lord.
that-
This was returnable on 2nd of April, and my lord,
I
there
was
are,
missing on that day. That is why.
My lord was in circuit. My lord.
Yes.
my lord, there are two other matters, my lord. Writ petitions, my lord, those are assigned to your lordship.
Madam, do one thing. You talk with. You mention before Justice Mantha. কবে একটা ডেট ফিক্স আছে আমাদের মান্থা সাহেবের সাথে কোনো ডেট আছে
15th of April, my lord, it was fixed. My lord.
কোনো আজকে যেমন দুটোর সময় ওর সাথে দেখেছি। একটা মেয়েটার ওটা লিখতে শুনেছে হ্যাঁ 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 wait. It will be sometimes next week. Let them fix. Let my. They will send the intimation on the next week. Any date. Let us.
On the next weekend. Much obliged.
Lord, may I permitted to mention application, my lord, application for stay, my lord. This matter was returnable on 17th of, my lord, February, but it has not come up, my lord. It will be listed, my lord.
Anybody appeared for the other.
Yes, my lord, yes, my lord.
Mention. You give a notice.
Yes, my lord, I'll give a notice, my lord.
You've given notice and
Not,
mention.
my lord, it's not here, my lord. I'm giving it. I have
Give a
served.
notice and tell us on Thursday.
I'm good.
Yes.
My lord, may I be permitted to mention one matter? That matter is running in the monthly list of April lordship as item number 44, my lord. My lord, the grave urgency is that I am out of service, my
Wait,
lord.
madam, wait for some time.
Due to my life, I have no livelihood, lordship. I have to pass my day every day.
Keep a watch. We will call the combined list. And please appear when the matter is called. Yes, call the list.
Item number 1, lordship, I am appearing for the appellant late.
My lord, item number,
Lordship, I am filing the affidavit in reply to their affidavit, supplementary affidavit in opposition.
my lord,
Subject.
my lord, I'm for the respondent, my lord. There was a direction by your lordship to file a supplementary affidavit in opposition for annexing the original advertisement, my lord, in question, my lord. If your lordship grant me leave, my lord, I can file, my lord. But in this matter, my lord, Sushmita Sadatta is appearing, my lord. She has not come to court today, my lord. I'm praying for only
Madam,
one day
copy-
accommodation, my lord.
It's a copy of CFC.
Liberty.
Lordship, the case of the appellant is that he participated for the post of soldier general duty. Lordship, he participated for the soldier general duty, for the post of soldier general duty. He secured 200 out of 200 marks being an NCC certificate holder. In spite of that, his candidature was rejected on the ground that he is a priority 5 list candidate. In spite of securing 200 out of 200, and there are candidates who secured lesser marks than the appellant but has been given appointment.
Have you got the supplementary affidavit?
My lord, I have served, my lord. And they have, my lord,
Supplementary, have you used any exception?
my lord.
Huh? They have used the exception.
I have filed an reply to that. I filed a reply.
My lord, they have filed, my lord, already, my lord.
Then why you are praying for time?
My lord, one day accommodation, my lord, because my lord, in this matter, Miss Shahadatta is appearing, my lord. She has not come to court, my lord, today for some personal inconvenience. Her health is not well, my lord. For that one day accommodation, I am seeking, my lord. If your lordship kindly grant me leave, my lord, I can file the supplementary,
Wait.
my lord.
Now, what is the matter? Tell us. Wait.
My lord.
Lordship, the matter is that Lordship, on 2018, there was a recruitment process conducted by the Army Recruitment Lordship, whereby the petitioner participated.
We heard, my brother and myself heard this.
No, my lord.
Was not
No, my lord. This is the first time, my lord, is
I'm
appearing in this before this honorable bench.
তাহলে কাল কি
The matter relates to, my lord, post soldier on general duty.
Yes, yes, you are a late arrival.
No, but can you see, my lord, the urgency is that, my lord.
He's praying. Your junior was here. He says that the lady has not come to court.
Oh, may I make it not today?
Affidavit গুলো ফেরত দিয়ে দাও। Day after tomorrow করে নিও। Yes, let's.
Well, day after tomorrow, I have some difficulty. Tomorrow, my lord, make it tomorrow.
ও বলো ওই যে একটা টু বি মেনশন
Friday. Okay.
ও ফ্রাইডে অন্য বেঞ্চ আছে না you people the matters are fixed either you pray for time or they pray for time.
No, I have
And
not taken.
we
I am
had
not.
a problem.
I am not paying any time, my lord, in this matter. What has happened, my lord, several.
Day after tomorrow.
Day after tomorrow, my lord, I have some difficulty, my lord.
What difficulty do you have, sir?
My lord, I have a matter, my lord, different. My lord, I have to.
The third বুধবার বৃহস্পতিবার রেখে দাও
Yes, my lord. As your lord. Obliged, my lord. Keep.
এভিডেভিট গুলো ফেরত দিয়ে দিয়েছেন তো
My lordship, Mr. Shordhar Amjad Ali, Learned Senior Advocate, is appearing for the appellant, my lordship. I'm praying for short passover, my lordship. On the last occasion, my lordship had asked us to prepare a chart, my lordship. It's prepared, my lordship. It's that matter with
who is
CP.
your other side yes where is he
Senior Mr. Shomo Mojumdar is appearing for the private
so
respondent.
all you do one thing every day go on praying for adjournment
Lordship, he's engaged in
Letters
issue number
this
13, my
week,
lord. It's a
nobody
fixed matter, my lord.
not this week come on next Monday
Lordship, grateful.
yes next
For the applicant this matter.
yes
Kindly remember, in that case where, my lord, there was a
we don't
yes, very well, my lord. Where the case, my lord, relates to, my lord,
সব ভুলিয়ে দেবে তোমার
and my lord, may I file my supplementary affidavit?
দাঁড়াও না তুই যাবে কোথায় চ্যালেঞ্জিং ফার্স্ট বেঞ্চ in cases an application for Mr. Ghosh yes tell us what is the matter
My lord, matters, my lord, relates to, my lord, that the appellant before your lordships is, my lord, the office.
we have disposed of the section 5
Section 5, and there was a, my lord, delay, and considering the merit of the matter, my lord, your lordships condone the delay, my lord. Now, my lord, fact is,
শোনো কার্তিক এগুলোতে আমাদের যেগুলো অ্যাপ্লিকেশন yes
but here, fact is, my lord, the
reply has been given
yes,
Eh?
my lord, everything is completed, my lord.
where is your reply
No, entire, my lord, recorders before your lordships in, my lord, stay application, and your lordships last day, my lord, wanted to.
they have used an opposition I find have you got this
No, opposition in respect of the, my lord, the section 5,
section 5
my lord.
ঠিক আছে
My lord,
তুলে দিতে হবে তাহলে Affidavits have been exchanged.
Yes, my lord.
We have disposed of both the cans.
Yes, no,
The-
only the section 5 application, my lord.
No, can also be disposed of saying that the appeal will be heard.
No, but since, my lord, the stay application is, my lord.
No scope of
Ja, ja,
stay,
ja.
lordship, that's what we
And
decided.
kindly see lordship's last order, my lord. Release the appeal along with the stay
and
application.
the appeal is coming together.
Yes, my lord.
তার ঠিক এই মেমোটা আর এই অন্য স্টে অ্যাপ্লিকেশন ইজ হোয়াট নাম্বার একটু খুলে দাও একটা মামলা নিয়ে সারাদিন চলবে না
Well, the fact is, my lord.
কেটে দাও ভলিউম দুটো ভলিউম এইগুলো সব রেখে দাও এইগুলো আলাদা করে
না ধরলে মশাই
অমলান দাও তো ওখানে কোনো এফিডেভিট অফ সার্ভিসের কপি আছে তাহলে কপি নোট করবো নেই
700 লাখ জিনিস ছিল 570 ঠিক
আরে ট্যাগার দিও না Yes, tell us.
But it emanates not from a order of censure, which has had a cascading effect on my promotional avenue. But an employee retired in 2009. But I have got a short list of dates, no, dear lordships, may not be. So this.
Yes.
There was an employee who superannuated in 2009, whose gratuity dues had been withheld on obtention of a legal opinion.
He has retired in 2009.
There was an employee who had superannuated in 2009. My client is not that employee.
I see. Yes.
His gratuity dues had been withheld on the basis of a legal opinion because the circular of Coal India, of the coal company of 2007, which prevailed, which was guiding that field. Now, this did not clearly say that an employee who had not vacated his quarters is entitled to his release of gratuity dues. But even today in 2025, that quarter remains occupied. That allotted quarter remains occupied.
By the person who retired.
By the person, yes.
That is Coca.
Coca. Coca Nuya. Now,
who are you?
But I am an employee an officer who has been imposed with the penalty of censure for not releasing the gratuity amount.
So then what happened?
My lord, he lodged a claim before the controlling authority under the Payment of Gratuity Act. Now, this ultimately resulted in an order having been passed by the controlling authority without any award of interest. Only the principal amount to be paid.
So, Coca's death retirement dues were withheld by you. You are Devojyoti. So for withholding the gratuity amount, proceeding initiated, you are censured. When is that order date? Date of that order?
Order of censure.
Censure?
Now, that's at page 193.
Give us the date.
It is at page 3rd of February 2014.
Against that, you preferred a
I'm sorry,
statutory
the
appeal.
appellate order is 23rd of March 2015.
Right, the punishment was censure.
Censure.
You preferred statutory appeal?
The punishment was withholding of increment for a period of 2 years without cumulative effect. That was also a minor penalty. I preferred an appeal to the board, I mean the appellate authority. The appellate authority reduced it to a minor penalty of censure. So that's the ultimate penalty order of censure.
You could have been satisfied with that penalty. Why did you invite this? Censure now, plethora of judgment, whether it will affect promotion or not, whether
Because
it
of a circular of Coal India, it affects.
the very good. Your censure, your minor punishment was altered and made censure in 2014. Then what happened?
15. Now, Lord, I applied for promotion immediately thereafter.
Yes. Then they denied you promotion.
Yes. But before that, when the charge sheet was issued against me, and I was already in the zone of consideration and not I had been recommended for promotion, even before imposition of that penalty.
Yes, then appellate authority passed the order of censure.
Censure.
Challenging that, you filed a writ.
Now, ultimately, I was given this promotion notionally from 14th of August 2014, whereas I claimed this promotion to be effective from the date when my juniors had been promoted. It's a difference of 8 months, roughly.
No, just a. But here says petitioner promoted from E5 to E6 on 9 September 2020. Your list
That's
of dates.
subsequent promotion. When I was deprived for the first time, I was an incumbent for promotion for E4 to E5. Please come to second page, second entry. 8th October 2015. Promotion to E5 notional seniority from 14th August 2014. I was granted this promotion.
That was after the order of censure. Very good. Then what happened?
I wanted this promotion order to be reckoned from December 2013. That is the date when my junior batch had been promoted. And I was already considered with them before the imposition of the penalty.
But why you say on 9 September 2020, you were ultimately promoted from E5 to E6?
That's E6 grade. But the subject promotion was E4 to E5, a grade below.
Yes, then what happened?
Now, please come to the reasoned order which Coal India Limited passed after the remand made by this Honorable Court. Please come to page 20 of the stay application, which is the order of the Honorable Single Judge, or not from the memo of appeal, whichever is convenient for your lordships.
Page 20.
20 of the stay application, or from the memo of appeal, whichever is convenient.
This is 27th September 2020.
22.
So you have no problem as regards E4 to E5 promotion.
That's the promotion which I want to relate back to December 2013 instead of August 2014.
instead of August 2014. So before you file the writ petition, after you file the writ petition, they promoted you to from E5 to E6. You have no problem with that.
No, that's not. I will only seek, if I succeed before your lordships, I will only get an antedated promotion.
To the post of E5.
E5 and consequently to E6. This will only carry a notional seniority from the date when my juniors had been promoted.
No, then your subsequent promotion order also.
This is consequential. If I am promoted to E5 grade on an anterior date, that is the date on which my juniors had been promoted to E5 grade, had this penalty order not been passed, then as a corollary, I also get promoted to E6 grade on the same date when the junior batch had been promoted to E6.
So that is which date? You were granted promotion from E5 to E6 in 2018.
I was granted in 2008. Yes, 18.
So what, show us your prayer in the writ petition.
My lord.
First. That what is your exact prayer? You left it as consequential maybe.
Please come to
page 82. Proceeding 23/7/2013. 23/7/2013. Where is, what is this 23rd November 2013?
That is page.
You have challenged 23rd November 2013 and annexed P7.
That's the memorandum, charge sheet memorandum.
Charge sheet was 23rd November 2013.
Yes.
Yeah, allegation. This is the charge sheet.
My lord.
Page 130.
Page 86 na keno? Why not page 86? Page 86 also আছে.
যে জন্য বুঝলো তো করে করে দিয়ে This is the charge sheet
which resulted in the penalty.
And what is P7? P7 is at which page?
Date বলো তো পারতো P7 এর ডেটটা বলো তো। That's the penalty.
Page.
Penalty is 193. 193.
190.
তো তাড়াতাড়ি এগুলো বলতে হবে।
This is 2015.
My lord. 2015.
This is P7. This page
193
is P7.
My lord.
Mr. Ali, you are waiting for which matter?
Mr. Mujumdar was erstwhile engaged in item number 2, but item number 3 conveniently present.
No, all the parties prayed for an we have kept কবে রেখেছো?
Item number 2. His learned junior said he is engaged in other court.
Mr. Mujumdar, we have kept it on Monday. Please don't take any further adjournment.
No, I didn't take
Because
it.
Mr.
I believe Mr. Ali was also not here.
No, Mr. Ali is there, my lord, Mr. Ali.
All right.
But
At the
convenient,
time of call.
Yes. Yes.
peremptorily fixed, my lord.
We will be there, Mr. Ali. He
It
will
is
come
not
on.
because of me, my lord. It is not because of me the matter is being adjourned. Day
No,
after,
an adjournment was prayed for on your behalf.
Passover.
Passover
Passover.
was prayed for when we thought that who at the other side. Then we found the other side was also not there.
No,
As
the
we
other
have
side
a
might have
bench,
submitted that
Mr.
Mr.
Bani, as we
Majumdar
have
is
a bench fixed at
engaged in other court.
as we have a
Anyway,
bench fixed
the
at
lordship has fixed it up on Monday. I believe you will be able to.
Yes. Yes, Mr. Wimdar.
No, my lord, when this promotion was denied to me, I had filed the writ petition once. Promotion being denied means with effect from 2013.
I think if you take us to the order, then it will be
My lord,
clear.
that's
The
not
facts.
more. It will take place, but the facts are very succinctly recorded in volume 2, page 478.
No, you said page 20.
As you wrote.
বাবা এসিটা চলছে না নাকি গো? শুনবো বলছি হ্যাঁ
So promotion since December 2013 and not from August 2014, the time from when it has been granted. The facts as called out from the pleadings are enumerated. One so and so retired in July 2009. Prior to his retirement, the ex-employee was issued a notice in prescribed form 1I, should be I, under the Payment of Gratuity Act for processing the payment of his gratuity dues. Despite handing over of the form, the said workman did not submit his claim for gratuity in the prescribed format with his employer. By a letter of 13th August 2012, the senior manager of ECL asked the agent to immediately inquire upon the factual position regarding the claim of the ex-workman so that appropriate action could be taken in the matter. By the said letter, it was also intimated that non-payment of retail dues was looked upon very seriously by the competent authority. Letter of 13th August 2012 was in reply to the request made by the ex-employee for disbursement of his retail dues. The said employee, instead of filing his claim for gratuity before the company, filed his claim before the controlling authority on 6th September 2012, 3 years after his retirement. By letter of September 17, 2012, the agent or deputy general manager informed the senior manager that the management is trying its level best to settle the retail benefits of the ex-workman. Furthermore, it was intimated that the wife of the ex-workman obtained an order of injunction from the lower court regarding disbursement of his dues. As such, without the order of lower court, no disbursement could be made by the management. Enclosed with the said letter was the opinion of the learned advocate given on September 3, 2012.
So you were the deputy general manager?
No.
By a letter, this
I was the
paragraph E.
I was the personal manager at that point of time, but not this was on record, not which had prompted me not to release the dues because there was a legal opinion on record, referring to an injunction order by a court at the behest of a wife of the employee, retired employee.
You are still in service.
I am in service. I am praying for promotion.
You have got the promotion, but from a belated
And
date.
yes, I want it to be
Very good. Then
during the continuation of the proceedings before the Assistant Labour Commissioner, a deposit of the gratuity amount payable to the ex-workman was directed to be made within a period of 1 month by an order of 17 July at the interim stage. The ex-workman chose to remain absent on July 17. Immediately upon passing of the said order, the management of Colliery deposited with the controlling authority the gratuity amount with a calculation sheet attached thereto on 6th August 2013, that is within a period of 1 month from the date of the interim order. By a letter dated 6th August 2013, the DGM of the colliery informed the ALC Central Asansol that pursuant to his order dated July 17, 2013, the gratuity amount was deposited by the colliery management on 6th August 2013. The same stand was again reiterated by a letter of senior manager dated 9 September 2013 issued to the LC Central. In the meantime, the ex-workman lodged a complaint with the chairman National Human Rights Commission regarding non-payment of his gratuity. Accordingly, the chairman issued a notice to the Secretary Ministry of Coal for early redressal of his grievances. Pursuant to an emergency meeting held by the management, the controlling authority was requested to disburse the gratuity amount. By a memo of 4th September 2013, the Ministry Director of the Ministry of Coal issued a notice to the Commissioner Coal Mines Provident Fund Organization with a copy to GM Shodhpur area to immediately redress the grievance of the ex-workman and furnish the factual position regarding his case with the National Human Rights Commission. Now, that was with a different authority over which I had no control. That was with the Coal Mines Provident Fund Organization. By a letter of September 11, 2013, the LC informed the senior manager that since a maintenance case was pending against ex-workman, which has been filed by his wife, and the ex-workman was not cooperating with the authority for early disposal of his case, the issue regarding payment of gratuity to Kokanunia was still pending with the ALC. Even though the gratuity amount was deposited by the colliery management, the case could not be disposed in haste as it would lead to further legal complicacy. Thereafter, memorandum of charges of 7th November 2013 was issued against the writ petitioner, which culminated into the order of 3rd February 2014 passed by the disciplinary authority and the impugned order dated March 23, 2015 passed by the appellate authority. By a memorandum of charges of 27th November 2013, the CMD, being the disciplinary authority, directed the writ petitioner to submit his representation within 15 days in respect of a charge of misconduct or misbehavior by him on which an action was proposed to be taken. By the said memo of charges, it was alleged that since a complaint was filed before the general manager on 6th August 2012 by the ex-workman regarding non-payment of his retirement dues, when the writ petitioner was the deputy personnel manager of the colliery, he should have taken the matter seriously and made efforts for payment of gratuity. There were acts of commission and omission on his part which tantamounted to non-fulfillment of duties and obligations contained under Rule 4.so of the Conduct, Discipline and Appeal Rules of Coal India Limited applicable to its subsidiaries, and also amounted to misconduct under Rule so of the rules. A reply to the memorandum was given by the writ petitioner. It was inter alia stated in the said reply that since no claim for gratuity in the prescribed format with the documents as required by the colliery authorities was filed by the ex-workman, he was not paid, even though initially there was a confusion with regard to the wife's claim on the retirement benefits of the ex-workman, but later the claim of his wife was negated. In the said reply of December 10, 2013, the petitioner claimed that since there was no dispute with regard to the amount of gratuity payable under Section 7(4) to the ex-employee, no deposit could be made by the management with the controlling authority by its own discretion. The writ petitioner submitted before the disciplinary authority that there was no negligence on his part regarding non-payment of gratuity to the ex-workman, and he had taken all steps as required under the Act. Learned senior advocate appearing on behalf of the writ petitioner submitted that there was no willful negligence or deliberate failure on the part of the writ petitioner to disburse the dues on account of gratuity to the ex-workman. The only circular that was prevalent at the time was the circular of June 5, 1987 issued by ECL. As per the 1987 circular, it was directed that every effort should be made for timely payment of workers' claim. It was directed that every effort should be made for timely payment of workers' claim. Gratuity payment must not be delayed for more than a month from the receipt of the application. In case of any dispute over wrongful claims of gratuity, the same may be deposited in time with the controlling authority. According to the writ petitioner, there was no dispute in respect of the amount of According to the writ petitioner, there was no dispute in respect of the amount of gratuity. Therefore, the deposit on account of gratuity was not made with the controlling authority. Furthermore, since no application for claim in the prescribed format was deposited by the ex-workman, the question of making payment to him within a month of receipt of the application did not and could not arise. By the order dated February 3, 2014 passed by the disciplinary authority, it was held that as per Section 7(2) of the 1972 Act, the employer was to determine the gratuity irrespective of whether an application for release of the same was made or not, and inform the person concerned and also the ALC. Under Section 7(3)(a), either gratuity amount was to be paid within 30 days or interest was required to be paid on the amount. Alternatively, written permission for holding up of the gratuity could be obtained from the ALC. It was recorded in the said order dated February 3, 2014 passed by the disciplinary authority that the provisions of the 1972 Act were either not understood or were not complied with by the petitioner due to lack of concern. It was
Now
after 3 years of the ex-workman's retirement that an opinion of the advocate regarding the pendency of a civil suit was obtained on September 3, 2012. 3 years from the date of retirement of the ex-employee were sufficient to obtain details of the case and consult the same with the area authorities. Things could have been finalized in September 2012 after receiving the letter from the area authorities. In the event the case was dealt with seriousness, the same would have been resolved in September 2012. The fact that it was not done so clearly shows lack of concern and seriousness on the part of the writ petitioner. Hence, it was ordered that a minor penalty of withholding increment for a period of 2 years without cumulative effect would be imposed on the writ petitioner. An appeal was filed by the writ petitioner and the said appeal was disposed of by the impugned order dated March 23, 2015. The appellate authority examined the grounds of appeal and came to the finding that due to a large number of gratuity cases pending at the area level or at the level of the controlling authority, an office order dated September 13, 2012 was issued on the subject for clarification regarding the payment of gratuity. The relevant portion of the office order read thus: non-application. Gratuity falls due immediately after retirement, death, termination and payable by 30 days regardless of application. Hence, gratuity must be calculated, employee legal heirs informed in Form L, and if no response is found, be deposited with the controlling authority with details and same be informed to the employee or legal heirs or nominee. It was held by the appellate authority that no specific reply was received from ECL as regards the practice prevalent prior to September 13, 2012 in respect of effect of non-receipt of applications from the superannuated employees on the gratuity amount to be released. In the memorandum of charge, it has been alleged that the efforts to pay gratuity to the ex-workman was the responsibility of the colliery management. Hence, the writ petitioner, being the deputy manager personnel, should have taken the efforts to pay the gratuity to the ex-employee. The appellate authority took into account the writ petitioner's concern with regard to imperative requirement for vacating the company's quarters before preferring a claim in respect of gratuity payment. Till the date of the impugned order in 2015, the ex-workman did not vacate the company's quarters allotted to him, and there was no certainty when the same would be done. Therefore, no misconduct could be alleged on the part of the writ petitioner. Mr. Lahiri further submitted that the appellate authority came to the finding that the role of Kokanuya in the entire issue was not fair, as also recorded in the order of ALC, video order dated September 11, 2013 and also later dated April 24, 2014, issued by the Director Personnel ECL to the Undersecretary to the Government of India, Ministry of Coal. Therefore, the contention of the writ petitioner that the ex-workman was seeking to withdraw all his retirement benefits without vacating the company's quarters could not be ruled out. The appellant authority came to the finding that the writ petitioner had not delayed the issue deliberately and the role of ex-workman was very dubious. It was, however, held that a prompt effort on the part of the writ petitioner could have resolved the matter at an early stage without further complications. Therefore, the appellate authority moderated the penalty of withholding increment for a period of 2 years without cumulative effect imposed by the disciplinary authority on February 3, 2014 to the penalty of censure. It was submitted that since the appellate authority held that there was no deliberate intention in delaying the gratuity payment to the ex-workman, the penalty of censure should not have been imposed. The writ petitioner should have been exonerated from the charges completely. The act of omission was neither deliberate nor willful and related to only one instance. Therefore, no misconduct could be imputed to the writ petitioner. He relied on the following decisions to corroborate his claim. Not for the time being, I skip over the decisions relied upon. Not this is really not on the definition of misconduct. Please come to paragraph 13 at page 31. On the second issue, Mr. Lahiri argued that during the pendency of the departmental proceedings, departmental promotion committee's recommendation from grade E4 to E5 was issued. The promotion order was issued on 24 December 2013, but unfortunately only 27 days before the issuance of the promotion order, the memorandum of charges was issued against the writ petitioner and his promotion was withheld even though he was the second senior most employee in the list. By an order issued by the senior manager dated October 16, 2015, it was intimated that since the writ petitioner's penalty was moderated to censure, with the order dated March 23, 2015, his promotion from E4 to E5 grade could be issued as recommended in the DPC meeting from August 14, 2014 with notional seniority and notional fixation of pay at par with those promoted in August 2014. Should have been December 2013. It's probably a misprint. However, his claim for promotion with effect from December 2013 could not be considered since he was not exonerated from the charges leveled against him when the candidates were considered for promotion by the previous DPC meeting. It was submitted on behalf of the petitioner that by withholding
At
promotion.
that juncture, however, his claim for promotion with a could not be since he was not exonerated. Charge sheet was September 2013.
Charge sheet was
Charge sheet was
November
27
2013. November 2013. 27th November 2013.
So 27 November 2013 was the charge memo issue.
My lord.
Claim for promotion could not since he was not exonerated. He could not have been because it was very nascent. 2013 was the charge. Yes, then.
It was submitted on behalf of the petitioner that by withholding promotion for 8 months, the petitioner, who was the second senior most in the seniority list of E4 personnel executives, his career had been ruined. The petitioner would be deprived of natural justice since the penalty has been moderated to censure, and there was no bar in releasing his promotion from E4 to E5 with effect from December 24, 2013. Censure does not indicate any duration of time and has no time bar, so there was no impediment in releasing the benefits 8 months prior from December 2013. In support of the contention, he relies on the judgment of Janki Raman for the proposition that when an employee is completely exonerated, he has to be given the benefit of the salary of the higher post along with other benefits from the date on which he would have been normally promoted but for the criminal or disciplinary proceedings. Mr. Banerjee, appearing for the respondent ECL, argued that the writ petitioner, being the deputy manager personnel, should have acted with seriousness and also in terms of the 1972 Act. There was no excuse for the deposit for not depositing the amount of gratuity with the LC. Please take note of the stand of ECL. There was no excuse for not depositing the amount with the controlling authority. That's the stand taken. Even if there was a reason for not disbursing the gratuity amount to the ex-workman or employee. Now, this is in view of the observation by the appellate authority, who observed that apparently the employee could not be said to have been flawed by reason of the dubious conduct of the retiring employee and by reason of the legal opinion based on institution of a legal case.
Now, what is the procedure? Your officer has to deposit the amount of gratuity to the assistant labor commissioner.
Not the Payment of Gratuity Act says that if a person retires within 30 days, the employer has to pay the gratuity amount. If there is a dispute, then the admitted amount has to be deposited with the controlling authority, who will decide such dispute not only with regard to the quantum but also with regard to entitlement apropos the legal heirs or any other claimant.
But that amount was not deposited.
Not deposited.
In view of a legal opinion.
Now, that legal opinion was on record after 3 years of retirement.
Now, what happened before the controlling authority?
He ultimately
order was passed to the effect that give him
the gratuity amount, but no interest.
Now, what was the final order?
That's the order of the controlling authority.
Oh, that interest was not awarded.
Although the Act provides for interest for belated remittance of gratuity amount, but the controlling authority had disallowed the prayer for interest and directed release of the gratuity amount only through an adjudicatory process.
Yes.
Because the stand taken by the employer was the coal company could not have been said to be flawed because of the conduct of the employee.
Yes.
Now, please take the second sentence of paragraph 18. He submitted that since a directive was issued by the Ministry of Coal on the inquiry made by the National Human Rights Commission, the image of the company was tarnished. The petitioner failed to maintain devotion to duty and acted in a manner prejudicial to the interest or image of the company. He neglected his work and was negligent in performance of his duty towards the company itself. Furthermore, the writ petitioner acted in breach of the provisions of CD and AR, as well as the provisions of the statute by omitting to perform his duty, and therefore the order of the appellate authority with regard to imposing minor punishment of censure was not unjustified or illegal, or materially irregular, or perverse in any respect to merit judicial interference. Having considered the rival submissions of the parties and the materials on record, I find that the impugned order of March 23, 2015 has been arrived at after considering all the representations made by the writ petitioner and also the grounds of defense taken by him. The General Manager, Shodhpur area, received a complaint on August 6, 2012 from the ex-workman regarding non-payment of his dues. He inquired into the matter on August 13, 2012. The area personnel manager, via his letter of 19 September 2012, replied to the query of 13th August 2012, stating that due to an order of injunction from Asansol Court in a civil suit filed by his wife, the dues of the ex-workman could not be disbursed without further order of court. The ex-workman made an application on 23rd August 2012 about the inaction in respect of the application dated 6th August 2012 to the General Manager under the Right to Information Act. It was intimated to the ex-workman that his dues could not be disbursed because of the order of injunction. Thereafter, the appellate authority under the RTI Act intimated to the ex-workman that there was no order of injunction against disbursement of the retiral dues to him passed by the civil court. By the impugned order, it was held that efforts should have been made by the petitioner to pay the gratuity of the ex-workman, which was the responsibility of the colliery management at that time. After issuing the initial form, which was to be deposited by the ex-workman himself, no steps were taken to pay the gratuity amount for 3 years. Even after receipt of the complaint dated August 6, 2012 made to the GM and the clarification circular dated September 13, 2012, no steps were taken to either pay the gratuity amount to the ex-workman nor deposit the amount before the ALC by the writ petitioner. Due to such non-payment, the ex-workman had subsequently on 6 September 2012 filed a case for payment of gratuity before the ALC. The management deposited a check with the ALC on 7th August 2013 pursuant to the ALC's interim order of July 17, 2013. Opportunity of personal hearing and to make representations were given to the writ petitioner. After considering the representations of the petitioner, the discipline authority decided to impose the minor penalty of withholding increment for a period of 2 years without cumulative effect on February 3, 2014. An appeal was filed before the appellate authority. The next paragraph, the petitioner was heard on so and so dates. He personally appeared before the appellate authority. Then the writ petitioner decided to withhold the payment of gratuity to the ex-workman due to the practice followed by the company or ECL in case of retired employees. His submissions that no charge of dereliction of duty could be leveled against him because of the administrative practice prevailing in 2009, which included payment of gratuity only after the receipt of claim in Form I as per the 1972 Act from the employee, was considered by the appellate authority. The office order of 13 September 2012 by the respondent company succinctly clarified the issue. The relevant portions of the office order of September 13, 2012 were reproduced herein below. Non-vacation of company's quarter. Gratuity should not be held up for non-vacation of company's quarters as has been decided by FDs earlier. The other dues like area leave wages, LCS, settling allowances, etc. has to be withheld. If no other dues is there for withholding, the gratuity be deposited with controlling authority with a request to disburse the amount after the person concerned vacates the public premises or quarter. From the above, it appears that prior to 13 September 2012, a practice was prevalent at ECL that in event of non-submission of claim in Form I by the superannuated employee, the gratuity amount was not released. In this respect, the Payment of Gratuity Act has also been misinterpreted by the colliery authorities at ECL. There may also be the practice in ECL to release gratuity amount only after vacation of company's quarters by the employee concerned. Owing to some confusion and wrong practices likely to be prevailing, the ECL management subsequently noticed the matter and clarified the issues for payment of gratuity in line with the provisions of Payment of Gratuity Act. The aforesaid comments of the ECL were contradictory to the charge levelled against the writ petitioner. So, I heavily relied upon the clarificatory circular of September 13, 2012, which in unequivocal terms had referred to a followed practice in the company as a whole, as a matter of policy. At point number 4 of the order dated September 13, 2012, it was clarified that gratuity should not be held up for non-vacation of company's quarters as has been decided by the office order. The ex-workman
This
was...
goes against you.
Yes.
This goes against you. That non-vacation was not a ground for withholding gratuity. So what is your argument to that?
But I said, please come back to that quoted portion in the previous page,
Page
35.
35, yes.
So that was a matter of policy.
What was the policy? That you have to you cannot withhold the gratuity.
No, please come to the second paragraph of that circular as quoted.
The above.
From the above, it appears that prior to 13 September 2012, a practice was prevalent at ECL that in the event of non-submission of claim in Form I by the superannuated employee, the gratuity amount was not released. In this respect, the Payment of Gratuity Act has also been misinterpreted by the colliery authorities at ECL.
So that embargo was also wrong. That even if Form 1 had not been given, you ought to have given the amount to the ALC.
Now, this can be looked at from two angles. One, I was following a past practice in not releasing, which only stood modified or clarified in September 2012.
So, when did he file the Form 1?
Form I, he had...
You ask your junior.
2012 he filed. He filed before the controlling authority. 2012.
2012. That is prior to his retirement. No.
After 3 years after.
3 years after retirement.
Now that circular, which is quoted at page 35, is appearing at page 156. Now, if your lordships kindly consider the circular in its entirety. 156.
But Mr. Mujumdar, suppose we hold in your favor that the imposition of censure was bad. Can we go to the extent of directing the authorities that you give him promotion when the juniors were appointed?
My lord, the only ground for deferring my promotion was that imposition of penalty. If that penalty of censure goes, then Lord K. Janki Raman steps in.
That is for them to decide.
No, that was a prayer in the petition.
Then if we set aside the order of censure, we cannot tell them that you give the promotion. That is a separate cause of action.
No, I have prayed for in the same writ petition. You please antedate my promotion because of this censure order having been by setting aside the censure order.
So suppose we set aside the censure order. Now under what provision I will give you this consequential relief?
The sole ground for withholding or delaying it was imposition of a penalty. And I have prayed for this. Set aside the penalty order and grant me antedated promotion.
Yes.
Now, this is one aspect of the matter. But first is there is no misconduct committed. If no misconduct is committed, then no penalty. If no penalty is imposed, then the only ground for withholding promotion goes.
Yes.
Second is not what happens if
So where did they say that we are not giving you promotion on this ground?
Not please, that recollect paragraph 18 of the judgment which I read.
Yes,
Submission
that
of
was
learned
just
advocate.
submission.
Yes.
There was no excuse for not depositing the amount of gratuity with the ALC.
Yes.
That you try to explain that I was following the prevalent practice. Now, you are saying now that imposition of censure was denial of promotion from the date of the juniors were given.
Yes.
Was there any note order to that effect?
Yes, yes. I just showed that.
And did you challenge that order in your writ? These two issues, please apprise us. Then you may proceed. You find out that, yes.
I'm not. If what happens if the penalty order goes? No, this is the first claim. Now, if the penalty order remains, if the order of censure remains, whether I can be denied promotion. Now, my lord, in the rules applicable to the coal company employees or executives, there is enumerated penalty. But no employer can impose an unenumerated penalty. Now, my lord, this classification of penalties has divided it into two parts. One is minor, the other is major. And I believe not there are copies of the rules with your lordships.
No, Mr. Majumdar, so you proceed with the order. So
My lord.
then you finish it off and then
My
come.
lord. But I was placing that page
We're at page 35.
36, 35. At point number 4 of the order of September 13, 2012, it was clarified that gratuity should not be held up for non-vacation of company's quarters, as has been decided by the office order. The ex-workman was also aware of the fact that in the event of non-vacation of company's quarters, gratuity would not be paid to him during the time of his retirement. The ex-workman's conduct was not fair, and he only had to make an application in Form I for payment of gratuity and also had to vacate the company's quarters. Therefore, the contention of the writ petitioner that ex-workman was trying to withdraw the retirement benefits without vacating the company's quarters was accepted by the appellate authority. This court finds that no explanation was given by the writ petitioner as regards the reason for failing to make payment to the ex-workman or deposit the same with the controlling authority, even after considering point number 4 of the clarification order dated order issued on September 13, 2012.
So you are harping on this. This finding is, according to you, not proper.
So, my lord, the court found
something which is derogatory to the appellate authority order. Because the appellate authority accepted the contention that he was trying to get back his retirement benefit without vacating
the court.
Yes. Had
a prompt effort been made on the part of the writ petitioner pursuant to the office order of September 13, 2012, unnecessary legal complications could have been avoided. This court sees no reason to differ with the reasoning of the appellate authority on that score. The writ petitioner's contention with regard to failure to vacate the company's quarters by the ex-workman prior to consideration of his claim for gratuity was also considered by the appellate authority as per the prevailing practice during the relevant point of time. The appellate authority held that the writ petitioner had not delayed the issue deliberately, and the role of the ex-workman was very dubious. However, a prompt effort on the part of the writ petitioner would have resolved the issue instead of unnecessary complication of the same. Therefore, the previous punishment was moderated to censure. The decisions in so and so do not come to the aid of the writ petitioner, since a statute is supposed to be read as a whole. If the argument that without a written application made under section 7(1) of the Act, payment could not be made on account of gratuity to a retired employee is accepted, it would render section 7(3) of the Act useless, lumber or dead letter. The Payment of Gratuity Act is a beneficial legislation, and the intention of the legislature must have been to facilitate the payment of the gratuity dues to the employees. The intention of the legislature cannot be to deprive an employee from the payment of his gratuity dues in the event an employee fails to make an application in the prescribed form. The argument on the issue that the claim of ex-employee was not disputed by the company and therefore did not fall under the purview of the word dispute as contemplated under section 7(4)(a) cannot be accepted. Even in case of a dispute, the employer was required to make a deposit of the gratuity dues with the controlling authority, and where there was no dispute, there can be no question of withholding the payment to the employee. In case it was withheld for some reason, it had to be deposited with the controlling authority. This court is constrained to hold that the argument enhanced on behalf of the writ petitioner is hyper-technical and, if accepted, would render the provisions of a beneficial legislation nugatory. Being fully aware of the provisions of the 1972 Act, the writ petitioner acted in breach of the same. The interpretation now sought to be given to the provisions of the 1972 Act to aid the writ petitioner is untenable. In the prevailing office circular of May 5, 1987, it was clearly stipulated that in case of any dispute about the rightful claimant, deposit was required to be made with the controlling authority. It is an admitted fact that there was an uncertainty or confusion regarding the rightful claimant of the gratuity amount. Since the wife of the retired employee filed a civil suit and the lawyer appearing for the employer by his written communication of 3rd September 2012 communicated that a subsisting order of injunction in the civil suit did not permit payments to be made to the retired employee. Hence, the amount should have been deposited at least in September 2012 with the controlling authority. As per the clarification office order of 13th September 2012, it was clearly intimated that the employees or legal heirs should be informed of the gratuity dues, and if no response is found from them, the same should be deposited with the controlling authority. After the issuance of the said office order, the payment of gratuity dues should have been made promptly, and the issue should have been considered seriously. Before the 1987 and 2013 circulars had been issued following the provisions of the 1987 and 2013 circulars have been issued following the provisions of the 1972 Act. Since admittedly there was no dispute between the parties regarding the dues payable to the retired employee, there was no legally tenable reason for withholding the same several years after the retirement of the employee. It was observed in J. Ahmed that had the employee being a young man who was to continue in the post for a long period, an inquiry could have been made as to whether he could retain a very responsible post. Given the imminent retirement of the employee and the fact that his service was extended from time to time for the purpose of completion of the disciplinary proceedings, the High Court came to the view that the employee was no longer in service as on date on which an order removing him from service was made, and therefore the said order was illegal and void. The Supreme Court upheld the decision of the High Court. In the present case, the delinquent employee had a long tenure of service at the time the charges were framed. The writ petitioner acted in breach of the statutory provisions tarnishing the image of the company as per the CD and AR, which was not the case in J. Ahmed. Therefore, J. Ahmed's case does not aid the petitioner's case in any manner. There was no breach of any statutory provisions while discharging the service in Inspector Premchand. An error of judgment in not seizing the tainted money during a raid was held not to be misconduct in the peculiar facts and circumstances of the case. Hence, it does not aid the petitioner's case. The primary question that was considered in Sikandar Singh was whether the loss caused to the employer due to negligent performance of duty was recoverable by way of filing of civil suit. In paragraph 34, it has been clearly held that negligence in performance of a duty under a contract of employment may give rise to disciplinary proceedings, but on the facts of the case did not give rise to a cause of action for recovery of money for the goods lost. As in the disciplinary proceeding itself, recovery of money from the delinquent employee can be directed by way of punishment. The said case in fact supports the proposition that negligence in performance of duty can give rise to disciplinary proceedings. The failure of the writ petitioner to comply with the provisions of 72 Act led to tarnishing of the company's image as per the Conduct, Discipline and Appeal Rules 1978. The case of UBI does not come to the aid of the writ petitioner as the charges were not established in that case in terms of conduct regulations applicable in that case. Having considered the reasoning of the appellate authority, I find that there is no illegality or material irregularity or procedural impropriety. Failure to act in accordance with the principles of natural justice in impugned order passed by the appellate authority. The conduct of the writ petitioner has to be assessed in the light of the statutory duties imposed under the Payment of Gratuity Act. The relevant section of the Act is reproduced below. Note that gratuity falls due immediately after retirement and payable by 30 days regardless of application. Hence, gratuity must be calculated, employee or legal heirs informed in. No, this is really a circular which has been quoted, not from the Payment of Gratuity Act. The word must indicates that the obligation to perform the same is mandatory and not discretionary. The writ petitioner is squarely in violation of the Act. The Supreme Court has restated the grounds of judicial review as enumerated below. Where there has been a violation of natural justice, the proceedings have been held in violation of statutory regulations prescribing the mode of such inquiry. The decision is vitiated by considerations extraneous to the evidence and merits of the case, or if the conclusions made by the authorities expressly arbitrary or capricious, that no reasonable person could have arrived at such conclusion, or other very similar grounds. Having considered the aforesaid grounds, I find that no case has been made by the writ petitioner meriting interference of the impugned order on the impugned grounds, on the aforesaid grounds. In the instant writ petition, just because an alternative decision could have been arrived at, cannot be a reason to merit judicial interference. Therefore, this court finds no reason to set aside the impugned order passed by the appellate authority. Immediately upon the said order being passed, the writ petitioner made representations on so and so dates for consideration of his promotion from grade E4 to E5 with notional seniority from December 24, 2013. The Departmental Promotion Committee recommended the promotion in its meeting dated July 24, 2015. The writ petitioner's promotion from August 14, 2014 and not from December 24, 2013. The petitioner made several representations to urge that his service career would be ruined if being the second senior most in the promotional list of 2013, his promotional increment was not fixed from 24th December 2013. The petitioner also made a representation on January 5, 2016 to the chairman for consideration of his representation for notional fixation. Such representation is still pending for adjudication. In the instant case, the writ petitioner has not been completely exonerated, and the disciplinary proceedings were pending against him when the DPC's meeting was held in 2013. The recommendation of promotion was kept in a sealed cover till the appellate authority's order was passed. The order of promotion to E5 grade dated October 8, 2015 was passed with effect from August 14, 2014 with notional should be seniority and notional fixation of pay, hence on facts distinguishable from Janki Raman. In state of MP versus I.A. Qureshi, at paragraph 8, it has been held that censure cannot be equated with a warning, as it is one of the minor penalties that can